Good afternoon, and thank you for joining us for this installment of Epic Insight. This is Brian Lenz, Director of Sales and Strategic Partnerships here at Epic Retirement Plan Services, and I'll be your host for today's call. With an ERISA landscape that's continually being scrutinized and increased UL enforcement, it's important as ever that you have a sound fiduciary process in place on the investment side of the house. Today, we're joined by Steve Weil of Iron Financial to talk through some best practices and positioning to make the most of your fiduciary offering, whether you're doing it in-house or through a third-party partnership. Steve joined Iron Financial in 1994 and is currently a partner and managing director of corporate retirement plan services. And prior to joining Iron, he was an independent market maker on the Chicago Board Options Exchange. Steve holds the accredited investment fiduciary designation and was selected by the 401k Wire as a top 300 most influential retirement services professional. Your line will be muted throughout the call today, but we're happy to field questions as we wrap up. So please enter those in the GoToWebinar questions panel, and I'll run those by Steve. Without further ado, Steve, take it away.
Well, thank you, Brian. I appreciate the nice introduction. And today's webinar is titled Fiduciary Responsibility for Plan Sponsors. And what the goal was today, some of you may have experience with fiduciary services in retirement plans. Some of you may not. Some of you, may just are not sure if it's something that's needed or not. So what I wanted to talk about today was, first of all, the state of fiduciary and what's going on with that, because there have been changes in the last 3 years, especially with a different administration in Washington. And I also wanted to talk about best practices, and if somebody is providing fiduciary services, what are best practices when providing those services, or if there's somebody on the line who's thinking of hiring a third-party fiduciary for their plan or their clients, what are some of the questions to ask? So I'll just jump right in. And the first thing that I wanted to talk about is, what's the litigation risk? So generally, the reason for hiring an ERISA Section 338 fiduciary is to protect the plan sponsor, the company, and potentially the advisor on the plan. And one of the reasons this has become more relevant in the retirement plan space is due to a lot of the litigation that has transpired in the last 3.5, 4 years, and it just seems to keep ramping up and increasing. So what I wanted to do is this first slide here, we just talk about what is the litigation risk out there. And there's all types of lawsuits that are going after plans and plan sponsors. One of them, if you see under investment news, the ramifications of the Supreme Court decision on 401k fee lawsuits. I don't know if people are aware, but 3 years ago, there was actually a lawsuit, Tibble versus Edison, that went to the Supreme Court. The Supreme Court ruled in favor of Mr. Tibble, who was a participant in the Edison International Plan. And the ruling stated that plan sponsors are responsible to monitor the fees associated with the investments in the plan. So what a good 338 will do is they'll be monitoring those fees. They'll be selecting the investments. They'll be making sure that all fees that are being paid in the plan are fair and reasonable. And it's not always about, a lot of people think if they just use the lowest cost fund that they're covered. It's not about being lowest cost. It's, when you're looking at fees, fair and reasonable for what that client is receiving. A lot of these lawsuits, people say, well, these are for the mega plan market. They're not going to affect smaller plans. And if you look under the box where it says the daily, there was an excessive fee lawsuit that says targeting a $9 million plan. This $9 million plan is a family-owned business out of Minnesota. There are 4 body shops, and they're anything but, what you would think of as a mega plan. So what we just want to make sure that people are aware of is, why not take that potential risk that you may have for your plan and look at the solution of what hiring an independent 338 fiduciary would do, because it would transfer that liability from the company and the plan sponsor and potentially, as I said, the advisor onto that 338 fiduciary. The next thing I want to talk about is what is the risk and what's going on with the Department of Labor, because they are the ones who up until now have been enforcing ERISA in retirement plans around the country. And I like this slide a lot because there's a few bullet points I think that really hit home to me. Number one is 65% or more of the time that there has been some type of investigation, you can see it resulted in a violation, and they favored the plaintiff in that case. So over half the time there is an investigation, there is a judgment, and it's resulting in a violation. You also look below that and see the amount of money. In 2017, the Department of Labor took in $1.1 billion in violations. And as we all know, the government is looking for sources of revenue, and this has become a source of revenue. In 2016, that number was $793 million. So this is something that they are looking after. 3 years ago, the Department of Labor almost doubled their field staff to go out and review retirement plans. And one thing that I heard is their minimum threshold used to be plans down to $10 million. Now that threshold has been plans down to $1 million that they are looking at. And if you look below that, there were 174,000 informal inquiries. So a lot of times plan sponsors or advisors will think, well, somebody's not going to sue me, but it doesn't necessarily, it starts with them just calling the Department of Labor, them being unhappy or them questioning something and not getting the proper answer. So when they are doing that, you have the potential of a case being opened regarding your plan, and that is the last thing you want to do. And if that happens, by hiring an independent third-party fiduciary, that becomes their situation to deal with, and not the business owners or not the advisor who's working with the outsourced 338 fiduciary. So what you may be aware, and we want to talk, what does the future hold? So what you may be aware of, some of you on the line, is there was a Department of Labor fiduciary rule that was set to take place, and it went into effect. And then the Fifth Court in Louisiana struck down the rule. So a lot of people in the industry said, well, that was struck down. They're not going to come back with anything. There's no reason to have that. The problem is, for that, the SEC decided that they wanted to take up a fiduciary rule. You've also had recently 11 states are deciding that they want to enforce fiduciary in retirement plans at the state level in place of the federal level. On top of which, you also now have the Department of Labor coming back and saying, we're going to come up with a new fiduciary rule. The prior administration in Washington to what we've had the last 2 years was a strong advocate of having that fiduciary rule. And just because, as we all know, the current administration isn't such an advocate and pressing that, that doesn't mean that that administration potentially could be in Washington 2 years from now, and we could return to the old environment where there is a strong commitment to having a fiduciary rule in the marketplace. Now, when you talk of, there's a new wave of litigation also. So I had showed you other types of plans and big companies and a small plan, but now they're going after other plans in other types of areas. So one of the things that they look at when we talk about, low-hanging fruit is plans without a process, proprietary products, where they think that a plan would pay more, that there's an arrangement for somebody potentially paying more than they'd otherwise pay. revenue sharing. When I am asked many times, what are the two biggest reasons for lawsuits relating to the investment, Steve? My answer is fund fees and revenue sharing. So revenue sharing is when the mutual funds are taking part of their revenue and sharing it back and subsidizing, be it record keeping, administration, custody, and that is not being properly disclosed. Where the industry is going on this, and where a good outsourced 338 fiduciary would be going on this, is looking for funds with zero revenue share. Lowest cost share class without any revenue. Or if there is still revenue that's being paid back, working on a record keeping system that has the ability to credit that revenue back to a participant. And these are areas that people are looking at. Our ERISA attorneys have also told us now that advisors are part of this mix now, that 25% of all new cases that they are seeing involve the plan, somebody going after the advisor for breach of fiduciary. And these are advisors who are not signing on as a fiduciary, but they are probably being deemed a fiduciary just by their function within the plan. As you see here, though, really the key to everything is a prudent process and following that process and not deviating from that process. So I know for some of you this may be just basic, but I just did want to just define an investment fiduciary. And we always say if someone has discretion, influence, or control, they're going to be a fiduciary. And they can be named in that document as the named fiduciary of the plan, or they can be a fiduciary, as I said, just by their functionality. And what is the risk of that when they are being deemed the fiduciary of the plan? Many plan sponsors and business owners don't realize that there is actually personal liability to them in sponsoring a retirement plan. And what they will tell you is, no, I don't have personal liability, that the plan is sponsored by the company and the corporation has the liability, not me. There's the corporate shield. Well, within any ERISA lawsuit, ERISA is the one type of lawsuit that there is no protection from the corporate shield. So they can actually pierce that veil, as the term a lot of lawyers use, and go personally after the trustee of the plan. So once again, there's another reason why you would want to bring an independent third-party fiduciary into the plan. Now, you can handle fiduciary liability in three ways. They can keep the liability and just say, I'm comfortable with it. I haven't had an issue for many years. I don't see anything changing here, so I'm just going to stick with what I have. Number two, you can hire a co-fiduciary and you can share that liability, or you can hire an ERISA Section 338 fiduciary and transfer that liability onto them. So there are two types, as I mentioned earlier, of fiduciaries, investment fiduciaries in a retirement plan. And a lot of people hear these numbers and they're not always sure what they mean or what's the difference. So there are two types of fiduciaries in a plan. There's an ERISA Section 321 fiduciary and an ERISA Section 338 fiduciary. To keep it simple, an ERISA Section 321 fiduciary gives recommendations. So they may put together a lineup of investments and say to the plan sponsor, here's the lineup that I've put together. Do you approve of it? Is there anything you'd like to add or take away from the lineup? And they are sharing the liability because both of them had influence within creating, whether even though it may only be saying I approve of the selected funds, they still had influence on the investments in the plan. So they still would be deemed an investment fiduciary and still have that liability. The only difference is under ERISA Section 321, there is an advisor who is sharing that liability with them, so they could both potentially be sued together. Under Section 338 of ERISA, the fiduciary has discretion, and the plan sponsor and the plan advisor do not have any influence on what investments are being selected into the investment menu. Once those investments are selected, the participants in the plan can self-direct within any of those funds in the menu. The 338 fiduciary then will be monitoring those funds and replacing those funds when they are not meeting criteria and staying within the parameters of their process. So one of the things I wanted to do also is compare, when you're looking out there at different fiduciaries, a little bit more detailed on the difference between a 338 fiduciary and a 321 fiduciary. And if you're hearing that somebody's saying that they act as a fiduciary, asking them, what type of fiduciary are you? Are you a 321? Are you a 338? And they may respond to you, do you know the difference? And I'd like to think, after spending some of your day today on this WebEx, that you will know the difference and see, where the value is in both of these solutions. So pretty simple, as we're seeing here, just to reiterate, an ERISA 338 fiduciary is taking complete liability for the selection, monitoring, and replacing of the investment options. The 321 is not. They will also accept liability for mapping the assets. So depending on what outsourced 338 fiduciary you work with, when a plan transfers over, be it from one custodian to the other, or just transferring over to a 338 fiduciary and staying on the same platform within the same record-keeping system, you need to do a mapping report. You need to map from the current large growth fund to the 338's recommended large growth fund, and so on down the line. And in doing that mapping report, a 338 will and should take liability for that. Another thing is taking liability and creating and adhering to the investment policy statement. An investment policy statement is a business blueprint for a retirement plan. And what's interesting, I've heard in different lectures and from ex-Department of Labor investigators, that is the second or third question that they ask a plan sponsor when they come in. Can we see a copy of your investment policy statement? It is not a law that you would need to have an investment policy statement, but it's certainly a best practices. It also should define the process of the selection, monitoring, and replacement of investments in the plan. So it would be hard, in our opinion, for someone to argue that there is a process and they're following it when they don't have an investment policy statement in their plan. And that is something that is very important. And I think I read recently that still 6 out of every 10 plans do not have an investment policy statement attached to them. It's a little higher, like 6.5. So that is something that a good 338 should provide for you. Questions to determine the type of fiduciary. So if a plan sponsor wants to offload as much liability as possible, a 338 fiduciary is who they should be looking to bring on. If the plan sponsor doesn't want to be involved in the investments and doesn't want the liability for those, a 338 should be hired. The one time we feel that a 321 makes a lot of sense is the plan sponsor understands the risk to himself or herself and the business, or it's larger companies that have an investment committee. The committee has people who are educated in the area of investments. They also may have taken out fiduciary liability service insurance, and they want to be part of the selection, monitoring, and decision making when investments in their plan are added or replaced. And that is an appropriate time where a 321 fiduciary would work just well. But I think, as we know, being in this industry, I think we've heard that 90% of retirement plans out there, I believe, are under $10 million. So they're going to really fall into the smaller plan market. And in that smaller plan market, as I like to feel we've demonstrated here, that 338 fiduciary really makes a lot of sense. I know there's a lot of people out there that feel that this is only a service that large plans should have, and I'm somebody who would take the other side of that, and I would say it's something very important for smaller plans, because when I see other smaller plans, they don't have a lot of documentation, they don't have a process, there is no investment policy statement. So adding a competent 338 ERISA fiduciary to a smaller plan is a great value and really changes that plan, in my opinion, quite dynamically. So there's some questions to consider if somebody was going to be hiring an ERISA 338. And what we want to do is, this is really as we get into start talking about best practices. Does that ERISA fiduciary have any kind of an industry level certification? How many plans do they manage? What is the AUM of their plans? Do they use proprietary funds? And that's an area I do want to take a moment and touch on that, because that is something that really red flags a lot of these lawsuits you see where there's lawsuits about using proprietary funds and then using proprietary funds with a higher expense ratio. Now, some of the firms that have had issues with this have been able to defend themselves. I don't want to name some of the fund companies out there, because I'll name one and leave them off, and I'm not trying to focus on any one company. But there was recently a lawsuit against a fund company where their employees brought suit against them about their funds within their 401k plan. And the judge actually ruled in favor of the company and not in favor of the plaintiff. And what they pointed out was that there was a definitive process that they had documented, that had been followed, and based on that process, they could justify why they were using the in-house proprietary fund. But many, many times, and unfortunately, our industry, like so many others, is so driven on price that you will see plans where people think that they are getting their plan for free or very little cost, and the plan is loaded with in-house proprietary funds. If you have a plan and 100% of the funds are from one fund company, there, in my opinion, there can't be a process. There is no process, because what's the selection? Any fund by ABC Fund Company? That is not a fiduciary process. So that is something that we really want to focus on. When we act as a 338 fiduciary, we would never act as a 338 fiduciary on any platform that had any kind of requirements for a certain percentage of proprietary funds, because to us that is a conflict, and that is something that, as you look out there in the industry, something that I think you really want to look at. It's something that is easy to look for. I'm not going to talk again about investment policy statement, but you can see asking people how important that is. And then what do the deliverables look like that you're getting? Are they plan specific? Are they generic? How are they delivered to you? Is there any participant education? Is there fund performance? Those are things to look at. What are the qualifications of the people at the company? Do they have CFA designations? Does anybody have accredited investment fiduciary designations? So internally, what kind of education and ongoing education has the staff of that fiduciary company undertaken? You also want to make sure that whoever you're hiring as a 338 fiduciary, that they have adequate fiduciary liability insurance. Yes, we like to think that all good companies are going to follow their process, and they will. But in case there's a lawsuit or there's an issue, you want to make sure that the 338 fiduciary that you have hired has adequate insurance to cover any claim against the plan. I also think a good question to ask a fiduciary is, who is their ERISA counsel? There are more than just one ERISA firm out there in the United States, but there are firms that specialize in this, and there's a smaller group at the top, but there are many good firms. What is their experience? Because that is something as a client that would be important to me. And then lastly, if the DOL does come in and there's an audit, what type of assistance are they going to give? Are they going to just say, hey, we just picked the investments, we can't talk to you or help you on that? That's not what you're going to want to hear when you have the Department of Labor in your office. So we think those are very important questions for you to consider when you're looking to hire a 338 investment fiduciary. So what are some best practices and what do they look like? So we feel that best practices is when the advisor or there is an advisor on the plan that's acting in the 338 capacity. Once again, if a plan accepts a 321 fiduciary and they say, oh, it's good enough, we really want to make sure, and they should really make sure, that they understand exactly what that means. I find that as I've talked to people and they hear the word fiduciary or they hear the word co-fiduciary, and should listen to that word co, because that certainly sounds like a sharing of something, that they understand what it is they're signed up to receive and what it is they're signed up not to receive. I think that's very important. Institutional share classes, whenever possible, always looking for the lowest share class of a fund once you've identified that manager. Making sure that there's a process to identify and handle revenue recapture in a way that's not a conflict and that is understood by everybody within the plan. And then deliverables, something that we feel is extremely important. Is the deliverables being, investment policy statement, some type of quarterly fiduciary reporting to the plan trustee, and then also quarterly education and performance reporting of the funds to the plan participants. Also, what type of participant access is provided for each of these participants? Is it one-on-one? Is it being done in the form of telling people to go into target date funds? Is it risk-based portfolios? Really being able to offer everything and letting the participants choose, in our view, is what we think is the ideal situation. Nowadays, you can offer everything, and through proper education with participants, letting them decide and giving them the ability to change that decision at any time in the future. So to summarize a little bit here, just, we've talked about fiduciary, what's going on in the environment, and as I hope I've talked about, it is not slowing down in our eyes, although a lot of people thought it would. If anything, it is picking up. There are endowments, universities, many different avenues now are being sued, and they're looking at the fiduciary practice within the business retirement plan, and that is something that's important. So just a little brief background on my firm, Iron Financial. We're headquartered here in Northbrook, Illinois. We actually have $4.5 billion in assets under management. We have 6 owner partners here at the firm. It's actually 34 staff now. We have 2 CFAs and 5 accredited investment fiduciaries on staff. Our business insurance coverage is $10 million per claim, and it's with Chubb. and we use the Wagner Law Group, which is the second largest ERISA law firm in the United States. We also, as I talked about industry accreditations, we also are accredited with CFEX, the Center for Fiduciary Excellence. CFEX is an independent organization that actually comes out, we pay them to come out to our office every year for 2 days, and they randomly select plans and audit our business and make sure that we are following our process and not deviating from that process. And I think that's also something very important. A lot of companies pay to keep auditors out. We're fine with that. We want to make sure that our process is running and that there are no issues with it, and we're glad to have an independent third party come in and look at what we do here. Currently, we act as a 338 fiduciary on over 2,900 retirement plans, and we think that versus some of the other potential 338 competitors out there, our process and how we select our investments and monitor our investments is different from other managers. We are a top quartile manager. Many 338 fiduciaries are top half. So if you're in the 50 percentile, the investments are fine. We just feel that if you're paying somebody that you'd like to keep them in the top quartile of the managers, it'll add more value on the investment outcomes in the end. So with that, I would be glad to open this up to any questions that anybody might have.
Thanks, Steve. As I mentioned, anyone on the line who would like to throw a question at Steve, please go ahead and enter that in the GoToWebinar questions panel there. But we had a couple that came in already, Steve. One, you mentioned and clearly showed that 338, for example, versus 321 is a better situation for a plan sponsor who's really not equipped to be chiming in on an investment decision or sharing that fiduciary duty, especially in the small plan space. Can you add any commentary on how that might affect or potentially be good for the advisory practice, specifically as it relates to scale?
Certainly. And whoever asked that question, thank you very much. So at times I've done this presentation in a different version years ago to groups of advisors, and I've started off that talking about time, and time's the one thing we can't create more of. We only have so much time in a day. So for an advisor on the plan, besides the plan sponsor, where the advisor gets a lot of benefit out of this, besides the fact that he or she will also get that protection of the 338, and that taking that off that advisor, is if you talk about the deliverables that are being done, including the investment policy statement. Well, if that's being done by the 338 and it's just delivered signature ready to the plan sponsor, and then every quarter a participant newsletter, we create a participant newsletter and a quarterly fiduciary report, and that goes to the plan sponsor with the newsletter to be distributed to the participants. So the time that it would take an advisor to create these quarterly reports, and that these quarterly reports are automatically sent to the plan sponsor, and the advisor, at least with our practice, is always CC'd on anything that goes to the client, that they're able to be in the loop and see what's going on, but they're not having to take the time and resources to create those quarterly fiduciary reports and those newsletters. And these reports are plan specific, and they're delivered directly to the plan sponsor and the advisor. Other service providers in the industry have a generic report, and they send an email that your plan report is ready. Please go to the website and pull the plan report off that website. And in our opinion, if you've taken the time to email somebody to tell them to go to a website to pull down a report, you could just deliver the report to them right there and take that step away from them. So that is something that we think adds value to that plan sponsor. Also, to that advisor. Also, if advisors are looking to capture rollovers, chart what you charge in the plan. If you're deemed the fiduciary, you can't have somebody roll assets out of the plan into an IRA and charge them 1% on a $300,000 IRA, and you're charging them. They could have stayed in the plan and done something for, maybe you're charging 30 basis points in the plan. So by hiring and bringing on an ERISA 338 and the advisor working in a non-fiduciary role, providing education, risk tolerance, gap analysis, retirement readiness, and working with their clients that way, I think that is going to allow them to be more profitable, but more importantly, be more participant-centric focused. And I think in this competitive environment of ours, we're all looking to grow business here. I'm sure that's why everybody's on this call. If you're out there going into a plan sponsor and saying, we do a great job of picking the investments, as we all know, that's really just a piece of the plan. Going in there and saying we have a whole program to work with participants and make sure they're saving enough, and when they do retire, that they're going to be on track. I personally think that's going to win you more business. I also think that the advisor bringing a 338 on and going to a potential client or even an existing client and explaining to them, I'm the quarterback here, I'm your ears to the ground, and the environment out there in the marketplace has changed. And we're going to bring in an independent investment fiduciary to your plan. And what that's going to do, Mr. or Mrs. Business Owner, right now you do have the fiduciary liability on the investments. And they're going to have the discretion to pick a menu of investments, and it's going to be their liability, and they're going to sign on in writing for this, and you aren't going to have that liability. Well, they aren't, but either is the advisor. So that's why, there are a lot of broker dealers out there who won't let their advisors act as a 338 fiduciary. What we see that we think something that works very well is a lot of times when there is a platform level 338 fiduciary or a plan level 338 fiduciary on the plan, and then maybe the advisor is acting as a 321. So they're giving investment advice specific to the funds within the plan, but the entire plan is covered. It's not covered on a per participant basis. That's another thing to be concerned about out there, that there are some 338s that I've seen who've marketed their services as free. And I think when you tell somebody your service is free, to me, it's almost an insult, because nothing is really free. But what that means is if they use their investments, they will be the 338, and that's what we call participant level coverage. The problem with that is if only 50% of the participants take up on that service, only 50% of the plan is covered. So you really, when you're looking for this solution and you're going to use it, want to make sure it's a plan level fiduciary, not a participant level fiduciary. Any other questions?
Yeah, I think we have time for one more. Can you comment on fees at all? You mentioned it, the free concept, but if someone were to work with a third party to handle 338 services, is there room in some of these plans for both a non-fiduciary consultant advisor who's going to be the face of the relationship and handle education and enrollment, coupled with a 338 managing the investment process?
Another great question. So first of all, I'd say, I do see fees and funds coming down. But I would say what we see, one of the things that we do here at this firm is if we are able to get a plan level statement from a company, we do a weighted cost and performance analysis of the plan. So we'll look at what funds the money's in times whatever that expense ratio is, and compare it to the same asset manager that we're using, let's say in large growth, and the dollars that are in that fund and getting that weighted average on there. But I have seen when we have done this, even recently, we feel we're saving on average 30 to 50 basis points. It's probably getting closer to 30 now, just because of fee compression, but still saving 30 basis points off the fund expenses. And our fee, I don't want to speak for other 338s, but our fee is 10 basis points, and that does include risk-based 338 managed models. So if we're having that and we're adding that service of 10 basis points, it can be justified one way, financially, by we're reducing the mutual fund expenses by 30 basis points in the plan. The other thing, I do think there's room for the advisor to still charge their fee. A lot of times when I talk to advisors, they'll say to me, well, Steve, so we're going to hire you. I get it. I'm comfortable. I want to do that. And I guess I have to drop my fee by 10 basis points. And I say, no, you don't. You do if you're charging too much and it's not relevant for what a plan that size an advisor should be charging. But if you're not, there's no reason you should, because this is a new service being added to the plan. So if it was nothing was changing and you were just adding a cost, then I see they can make that argument. But I don't think they have to make that argument. I mean, I would also say that there's plenty for an advisor to do in a plan, even if they're not picking the investments. I mean, number one, they can talk to that they're monitoring us for the for the plan sponsor. So I talked about risk tolerance, gap analysis. Are they saving enough? There's many different things, and I think that's a really good value. So there's certainly room for an advisor to charge their fee on the plan.
All right. Well, thank you, Steve. That does it for today. I appreciate your time, and thanks to Iron Financial as well for letting you join us. And for everyone on the phone, appreciate your time and look forward to seeing you at the next installment. In the meantime, appreciate the partnership. Thank you all and have a great afternoon.